Hi, everyone. This is my 21st session of Arbitration Bootcamp. And what I'm going to ask at the end, and I'm reminding you right now, is that if you have any great topics that you'd like to hear about, please let me know. I didn't know that I'd come up with 21 topics, and I'm starting to run out of some. So if you've got any ideas, please do send them along. This session, called Things You May Not Have Noticed in Arbitration Legislation, was inspired by my experience in discovering new things about the Domestic Act or the model law in the course of my practice. And so every time I was consulted in a case, I would invariably find something that was a surprise or something that I looked at in a whole new way because I was looking at it in a different context. So that is the kind of background that I bring to this specific topic. So I guess what I'm saying at the outset is please do what I should be doing every single time I start a new case, and that is read the legislation from beginning to end and read the rules from beginning to end. As usual, at the end of this session, you're going to get a copy of the video. I've also prepared a list of the various arbitration bootcamp sessions I've had over the past almost 3 years. And you can catch up on those at your leisure. And I also will send you links to the cases and the legislation that I refer to in this session. For those of you who don't know me, I'm a partner at Learners. I am an independent arbitrator, and I'm also on the roster for Arbitration Place. I'm also an editor and writer of Arbitration Matters, which is a regular blog that gets circulated to subscribers for free on cases on arbitration issues as they are released across Canada, and you get sort of a short summary of the case and some commentary on its significance to the arbitration world, mostly in Canada. I've got my Q&A box open, so if anybody thinks of something while I'm speaking, please do put it in there. If I'm talking and I don't see the question, I will get it to it before the end of the session. And I promise, as usual, I'll have you out by 1 o'clock. So things you may not have noticed in the legislation. The most important comment here is that all of the domestic and international legislation is not the same. And so while you will see great similarities in concepts and even in provisions, there are some very small subtleties or nuances sometimes, which means that it is very important to look very closely at the legislation that's applicable in order to appreciate specifically what rights, remedies, etc. there are under that legislation. Also remember that in Quebec, there is a single piece of legislation which covers both domestic and international arbitration, and it's very much modeled after the model law. There are a lot of complexities with the current state of the legislation across the rest of the country. So some provinces have adopted the model law for their international legislation without any changes. Some have made some changes with the model law. Some provincial domestic legislation is based on the Uniform Law Conference of Canada. We see that in Ontario, Alberta, Manitoba, Saskatchewan, New Brunswick. BC is a bit of an outlier because it had legislation previously, which was very close to the legislation in the provinces that I've just mentioned. It has released what people still call the new act, although it's dated 2020, which has significant changes and brings that province's domestic legislation much more in line with the model law. So there are some commonalities, as I say, but some very important nuances, which some of which I'll raise today, but some of which you'll learn as you look at the legislation in detail. So one of the most important provisions that you should take a look at in each domestic act, for example, is the contract out provisions in the legislation. So, of course, one of the most important parts of arbitration is the principle of party autonomy, and that is reflected, of course, in the legislation. There are specific provisions that parties can contract out of, and there is a list of them, and I'll go through a few of them in a moment, but there is a list of those which the parties cannot contract out of. And that is extremely important because most of them relate to standard fairness issues. And things that if they weren't part of the arbitration would actually potentially violate principles of natural justice and affect the integrity of the arbitration. So I'll start with the Ontario Act because it's the one that I'm most familiar with, and some of the other our legislation, as I've said, models itself after the Ontario Act, or they're similar in any event. So Section 3 of the Ontario Act says very specifically that parties can agree to exclude provisions in the Act except for a limited number of provisions, and they're all for policy reasons. So Section 19. The parties cannot contract out of the right to be treated equally and fairly, or the right to be given the opportunity to present their case and respond to the other side's case. A slight difference in the BC legislation, which says that parties shall be treated fairly. It doesn't require that the parties be treated equally. I wonder if that's in fact significant at all. Because treating parties fairly may not require that they be treated equally. And one of the things that occurred to me when I first read that provision in the BC legislation was the fact that some cases are simply not symmetrical. And so if the concept is that to provide parties, to treat parties fairly, it requires that you allocate the exact same amount of time to each of them in their case, that just may not be necessary in order to treat the parties equally and fairly. And many of you, and I have certainly been involved in cases that are asymmetrical in that sense. So I'm just hypothesizing about a situation in which that provision may be enacted in the way I've suggested. Another exception, Section 39. Parties cannot contract out of the provision that requires or permits the court to extend the time that the parties agreed to for the delivery of the award. So this is an exception to what we would normally call party autonomy, where the parties agree that the award shall be delivered within a certain period of time. And one example where you can see the justice of excluding that requirement is, for example, when the arbitrator becomes ill. And the argument then is that if the award has not been released within the time frame that the parties agree, the arbitrator becomes functus, which certainly is not, I'm sure, the intended consequence for the parties. And so the alternative, of course, is that the uncertainty may actually result in one party being happy and the other being unhappy. But as a matter of fairness, the legislation has an exception which allows the court can extend that provision. And the fact that it is the court that is making the extension, of course, means that neither the arbitrator nor the parties should rely upon that, which means there really should be best efforts by the arbitrator to meet that deadline. And again, if there are extraordinary circumstances, there may be the ability for, or the court may grant that extension. Another exception is the parties cannot agree to exclude the set-aside right in the legislation. The award can be set aside for fairness reasons. There's a problem with the formation of the tribunal. There's a problem with the appointment of the tribunal. There's a problem with whether an arbitrator acted within the jurisdiction given by the parties. There's a problem with whether one of the parties was treated fairly. All of those are absolutely essential to ensure the integrity of the arbitration, and the parties may not contract out of that right. Now, that's not to say that the parties must agree to an appeal. And in the domestic legislation, parties may contract out of the right of an appeal, which is obviously a review by a court on the merits of the proceeding. But there may be, in some legislation, limitations on the extent to which there may be an appeal. So, for example, under the new BC legislation, unless the parties agree otherwise, there is only an appeal on a matter, a question of law. Under the international law, whether the parties can specify that they intend that the domestic legislation applies and thereby take advantage of appeal rights is uncertain and depends on the seat of the arbitration. So if you are acting in an international arbitration and are trying to be creative and ensuring that the parties have appeal rights, that's something that you're definitely going to have to research. Now, people who are familiar with and work in the world of international arbitration don't have any concern at all with the loss of rights to appeal. It's really something that seems to be considered and talked about in the domestic arbitration world. So that's one. I guess I'm now at two things that people may not notice in the arbitration legislation. Number three is the ability to contract out of the prohibition against an arbitrator acting as mediator. And this may be a bit of a head scratcher because we know about the common practice of Med-Arbs, in which clearly the arbitrator also acts as a mediator. But unless the parties contract out of it, it's not permitted. So Section 35 of the Ontario Act in particular says, an arbitrator shall not conduct any part of the arbitration as a mediation or conciliation process or other similar process that might compromise or appear to compromise the arbitrator's ability to decide the dispute impartially. And again, the parties can contract out of that provision, but it must be done very carefully because of the requirement that an independent and impartial arbitrator is the rule. Now, the parties again can contract out of that. And you may wonder under what circumstances that would be desirable. But if, for example, it's something that the parties want as a part of the Med-Arb process, that is something that should be dealt with in a way that allows the parties to fully understand what they're giving up and understand the transition between the arbitration process and the mediation process, which requires a very detailed mediation arbitration agreement. And again, parties, if they wish, can contract out of independence and impartiality. Independence relates to the relationship that the arbitrator may have with the parties. Impartiality is something that refers to the arbitrator's state of mind, and it is something that is expressed in the arbitrator's conduct. It gives the court who may hear a challenge a sense of whether the arbitrator is acting impartially. And this, again, is something that may arise in a mediation part of a Med-Arb where a party may have some concerns that the arbitrator is no longer impartial as a result of the way the Med-Arb is conducted. The fourth part of a point in arbitration legislation that parties may not have noticed is the concurrent role of arbitrators and the courts. And a lot of parties don't appreciate that there is a role for the courts in arbitration. And I talked in one of my previous arbitration boot camps about the details about that interaction. But even the simple idea that the parties can contract out of arbitration, or out of courts, and buy into arbitration for the simple purpose of case management. So, for example, if parties would like an arbitrator to deal with undertakings and refusals motions, summary judgment motions, other kinds of motions in order to avoid the long court delays, as a result of party autonomy, parties can contract out of the litigation for that strict purpose, for that sole purpose, and then go back to litigation once those interlocutory matters have been resolved. Or if it's a summary judgment motion, which results in the dismissal of the action on all issues, there is nothing to go back to the court for. So that's something that counsel who are trying to streamline litigation and avoid as much as possible the long court delays can consider. So you're kind of opting into arbitration and opting out again and back into the court system. But the legislation itself provides for a role of courts inside the arbitration process. So, for example, it may be that if the parties do not have a mechanism in their arbitration agreement for the appointment of an arbitrator, and they can't agree on an arbitrator, then the court has a role to play, and the parties may apply to the court for appointment of an arbitrator. The court obviously has a role to play in an appeal or a set-aside of an award. There's also a role to play for the court in interim measures and arbitrator challenges. And some of these procedures are dealt with in institutional rules that parties may agree agree upon. And so they may determine that some of these issues may not be decided by an arbitrator, but they should be decided by the institution, and thereby maintain the confidentiality that most people are looking for when they choose arbitration. Another thing that parties may not notice or counsel may not notice in the legislation is something that I think is actually really important and is often overlooked, and that is the correction interpretation of an award that can be done after it is issued. So within 30 days, there is an ability of the courts or the arbitrator on their own motion to make certain amendments to the award. So for example, under the Ontario Act, a party or an arbitrator on their own initiative may correct typos, errors of calculation, and similar errors of the award. And that makes complete sense. Those kinds of issues do not result in a reconsideration of the merits of the dispute. A party or the arbitrator on their own initiative may also amend the award to correct any injustice caused by an oversight on the part of the appeal tribunal. So to correct an oversight, that's something broader than a slip up or a typo. Or the party or the arbitrator may ask the arbitrator to make an additional award to deal with a claim that was presented but omitted from the earlier award, an oversight. Now, the rights under the model law are actually quite different. Within 30 days, a party or an arbitrator on their own initiative may correct typos, errors in computation, clerical, or other errors of a similar nature. So that is consistent with what we see in the domestic legislation. But after that, the process is slightly different. If the parties agree, they may request the arbitrator to give an interpretation of a specific point or part of the award, but the parties must agree. Or if the parties agree, the arbitrator may make an additional award as to claims presented but omitted from the award. So under the Ontario Act, that may be requested by one party or on the arbitrator's own initiative. But under the model law, both parties must request that the arbitrator consider an additional award if a claim was presented but omitted from the award. So the most significant part of this 30-day period is it means that the arbitrator isn't functus until this 30-day period expires. But you can see there are limits. This is not an opportunity for parties to ask an arbitrator to reconsider certain parts of the award that party doesn't like. The jurisdiction is actually very narrow. And the model law requires the parties to have a greater level of cooperation because some of the relief can only be granted by the arbitrator if the parties jointly request it. The arbitrator may refuse to grant that relief and may do so because of the arbitrator's view that goes beyond the provisions of reconsideration or looking at typos, etc. And arbitrators will often say, I decline to reconsider my award because it goes beyond what's permitted in those provisions. And you can imagine some circumstances in which that can result in an injustice to the parties. And there's one particular case that those of you who have been listening to my Arbitration Bootcamp will know that is a bit of a bug in my ear, because in my view, it diverges quite significantly from some of the other case law. And that is the case of Escape 101 Ventures, Inc. against March of Dimes, a decision of the BC Court of Appeal at 2022, BC Court of Appeal 294. And a very brief summary of the issue is that one party brought an appeal. The parties agreed that the arbitration's summary of the evidence, so the facts, were wrong. And the significance of that was a difference in the amount awarded of several $1 million. So it was a very significant error on the part of the tribunal, and it was an error of fact. And as I've said just a few moments ago, under the BC law, there is no appeal for errors of fact unless the parties agree. So what the court decided was that a material misapprehension of the evidence on the face of the record going to the core of the outcome is an extricable error of law and subject to appeal. So that court heard the error of fact as something which came within the realm of an appeal. And this is a controversial decision, but it's a good example of the limitations that are found in the provisions I've just talked about with respect to the arbitrator's ability to reconsider an award. And so the parties had to go through an entire appeal process to correct evidence and findings of fact that both parties agreed were incorrect. And you can read about that case in more detail in my Arbitration Matters website. Another issue that's often overlooked or confused by counsel in the legislation is the meaning of the word costs. Costs in arbitration does not mean the same thing as costs in litigation. And I see that counsel often struggle with that concept. Unless parties agree in their arbitration agreement, or they're in a regime where the court costs do apply, the concept of costs do apply, arbitration costs are very different. So first of all, there's no tariff or scale referred to, for example, in the Ontario Act. So arbitrators are not bound by the tariff or scale in the rules of practice. In Alberta, Manitoba, and New Brunswick, the legislation specifically refers to solicitor and client or party and party costs. And so the rules of court relating to costs are much more applicable. But the definition of costs, for example, in arbitration is not the same as in litigation. In Section 54 of the Ontario Act, the arbitrator has the power to order costs of the arbitration, which is the party's legal costs, legal expenses, fees, and the expenses of the tribunal, and any other expenses related to the arbitration. So that would include the tribunal's fees and disbursements, but it would also include any other costs of the arbitration, such as the costs of the arbitration venue. The arbitrator has great flexibility under the legislation. And for example, although it's not provided for in the Ontario Act, for example, arbitrators may consider offers. So there isn't a strict Rule 49 provision as we see in the Ontario Rules of Civil Procedure, but the court may consider whether the arbitration tribunal may consider if one party made an offer to settle that was more favorable than the outcome, or at all. And this is in fact specifically provided for in the ADR Institute of Canada rules, which the parties may adopt. The arbitrator may also make a distributive costs award, although that is very unpopular, particularly I'm thinking of cases in the Ontario Court of Appeal where there is no ability for courts to give distributive cost awards. And those are essentially costs that are awarded on an issue by issue basis. But there is nothing which prohibits tribunals from making distributive cost awards. In other words, there is great flexibility in what an arbitrator may do. The principle that the arbitrator or the tribunal must consider is reasonableness, and that's what the case law says. Reasonableness as to the time spent, the rates, the allocation of work done by the parties, etc. The arbitrator's costs. So an arbitrator may interpret this as full indemnity costs, so is not constrained by the tariffs in the rules of court. And usually the party that was a substantial winner will get a favorable costs award, unless, of course, the parties decide otherwise, and they may decide that they will bear costs equally, for example, in their arbitration agreement. If you want to know more about costs in arbitration, I recommend the ICC Commissioner's Report, Decisions on Costs in International Arbitration, and increasingly these kinds of issues that start in international arbitration are being absorbed into the domestic arbitration context. I've given you a link for this report in the document that I'll send to you after this webinar. The model law itself is silent as to costs, but there are a number of institutions, international institutions, which provide for costs. So there's certainly nothing in the model law that prohibits it. Again, the seat of the arbitration is absolutely essential in determining what the regime for costs should be. Certainly, if both parties agree that costs should be granted, even if the seat doesn't provide for it, the tribunal may make a costs award. Another issue that counsel often overlook is one of my favorite topics called separability. This is a critical concept in arbitration, but it's often forgotten, or the significance of the principle is not fully appreciated. So it arises whenever there's a challenge to the contract, which includes the arbitration agreement, which is a very common challenge to an arbitration. You see this principle of separability in both the domestic and the international legislation, almost the same language. And it's related to the fundamental concept of competence, which provides that the arbitrator has the jurisdiction to decide their own jurisdiction. So if we look at Article 16, sub 1 of the model law, we see the concept articulated as follows. The arbitral tribunal may rule on its own jurisdiction, including any objections with respect to the existence or validity of the arbitration agreement. A challenge to the arbitration agreement or the contract. For that purpose, an arbitration clause which forms part of the contract shall be treated as an agreement independent of the other terms of the contract. So a challenge to the main contract does not automatically mean that the arbitration agreement will be declared invalid or void, even if the main contract is declared invalid or void. So there is separability between the main contract and the arbitration contract. And that has an important public policy purpose, which is that a party cannot avoid arbitration and have the dispute moved to the courts simply by alleging that the contract in which the arbitration agreement is found is invalid. That issue gets decided by the arbitrator. And that's part of the competence principle. If the arbitrator finds that the contract is void, that doesn't necessarily mean that the arbitration agreement is void. And again, this is the concept of separability. So there must be a separate finding that the arbitration clause is invalid. So for example, if the main contract is void for unconscionability, mistake, misrepresentation, or induced by fraud, or even if one party alleges that there was no agreement at all, if there was an intention on the part of the parties to arbitrate, there may be a finding that the main contract is void, invalid, etc., but that the arbitration agreement remains valid and the dispute is to be heard by the arbitrator. So again, if one party sues in court on the basis that the contract is void, the party which wants to rely upon the arbitration agreement applies for a stay in the court proceeding. And if the court determines that it's arguable that the matter falls within the jurisdiction of the arbitrator, the litigation is stayed and the matter goes to the arbitrator for resolution. There is a complex discussion which I've referred to in the material that I'll send to you with the various references. There is a paper that was prepared by Professor Anthony Damesis out of Ottawa U on the possibility that the concept of separability is different in the domestic legislation and in the international legislation, and also that there perhaps is a different concept of separability in the common law. So that's a lot more complicated that we need to get into today. But what it gives you is a sense of the complexity of the issue, and I've given you an overall summary of what the purpose is, but it is an extremely important one, given that many challenges to arbitration are based upon a challenge to the contract itself. And it's one that counsel really do need to consider carefully. Another issue that counsel often don't realize in the legislation is how jurisdiction challenge determinations are being decided. This covers the challenge to the court's jurisdiction on the basis that on the arbitrator's jurisdiction, and the issue will go then to be determined based on the legislation, and the legislation in both the domestic and the international act provide for challenges to jurisdiction. And I've already talked about challenges to the validity of the contract, but there are other reasons that parties may challenge the jurisdiction of a tribunal. For example, the dispute does not fall within the scope of the arbitration clause, or the parties to the arbitration are not signatories to the arbitration clause, and so are therefore not proper parties to the arbitration. So whether the jurisdiction issue is decided as a preliminary matter or with the merits is something that's addressed in both the domestic legislation and the model law. And a matter might have to await the determination on the merits if the arbitrator decides that whether there is jurisdiction or not is bound up with a determination on the merits. And so the arbitrator must hear all of the evidence in the arbitration in order to decide whether they have jurisdiction. So the issue of jurisdiction may be decided as a preliminary issue or in the final award. If it's decided as a preliminary issue, it leads to an order or a ruling because it's a procedural determination and it doesn't give rise to an appeal right. It may well give rise to a grounds for set aside later, but it does not give rise to an appeal right because it's not a final award. And if someone is challenging the jurisdiction of the tribunal, the challenge must be raised immediately, for example, before a defense arises. The arbitrator then has the right to determine whether it should be resolved as a preliminary matter or not. And under the domestic Ontario legislation, we see that in Section 17. The model law provides that the court review, which will follow if a party does not like the decision of the arbitrator on whether it has jurisdiction or not, the court may review the arbitrator's preliminary jurisdiction decision only if the tribunal rules that it has jurisdiction. In the domestic legislation, a party may challenge the decision of the arbitrator in court, regardless of the decision made by the arbitrator, has or has not jurisdiction. And there are protections in the legislation for example, tactical jurisdiction challenges. The arbitration proceeds while the court challenge is ongoing. And once the court has rendered its decision on a review of the ruling of the arbitrator on the jurisdiction issue, there is no further appeal. So again, this promotes finality and no further delays in having the arbitration proceed. If the arbitrator decides the jurisdiction matter in the final award, it is then subject to appeal and set aside, which is the case in every final award. So the grounds for challenging the jurisdiction award will be the regular basis for appeals or set aside challenges. We're up to 9 now. The 9th issue that council often don't appreciate in the legislation is what is the effect of the arbitrator's termination? Does it terminate the arbitrator's mandate personally, or does it terminate the arbitration completely? And this is, of course, important when a party challenges the jurisdiction of a tribunal, challenges the independence or impartiality of an arbitrator, or the arbitrator resigns, becomes sick, etc. So it's not apparent in the legislation that this is an issue. So you must understand the way the legislation works in order to appreciate this. This is something that, again, should be avoided in the drafting of the arbitration clause. And many of the issues that I've raised throughout this whole Arbitration Bootcamp series are flags that can be addressed ahead of time by a good arbitration clause. So in Ontario, Section 14 says an arbitrator's mandate terminates when the arbitrator dies, resigns, or is removed. Under Section 43, the arbitration itself terminates when the tribunal makes a final award. The tribunal terminates the arbitration, for example, when a claimant fails to proceed and continuation of the arbitration is not necessary, or the arbitrator's mandate is terminated. And if you read that between the lines, it means that if the arbitrator's mandate is terminated, and the parties have provided that only that arbitrator can hear the arbitration, that's the end of the arbitration. So that explains why it's very important in the arbitration agreement to provide a mechanism for the choice of arbitrator if the parties cannot agree, or if the chosen arbitrator is unable or unwilling to take carriage of the arbitration. The model law is similar, Articles 15 and 32. My 10th ground, or example of things that parties and counsel often don't appreciate, is the evidence that is adduced at arbitration. It's commonly said that the rules of civil procedure and the rules of evidence in court don't apply to arbitrations. But what does that mean? The domestic legislation in pretty much all of the provinces that I've identified say specifically that the tribunal is not bound by the rules of evidence and has the power to determine the admissibility, relevance, and weight of the evidence, and may determine the manner in which evidence is admitted. So it's a very broad jurisdiction of the arbitrator, which is very much complementing the broad jurisdiction elsewhere in the litigation, which allows the arbitrator to determine the process of the arbitration. In BC, the language is similar. The tribunal must admit all evidence that would be admissible in court, may admit other evidence that the tribunal considers relevant, and may determine, subject to the rules of natural justice, how evidence is to be admitted. Ontario is a bit of an outlier. It says the evidence, including admissibility, is to be determined in accordance with the Statutory Powers Procedure Act, which is essentially the same evidence as a statutory tribunal, and that nothing that is not admissible by court by reason of a privilege, nothing will be admitted that is not admissible in court by reason of a privilege. And so query whether there are really any differences in all of this legislation. In other words, the tribunal has very broad jurisdiction to admit evidence in order to ensure that the parties are treated fairly and each side has the ability to respond to the other side's case. The model law, Article 19 sub 2, is similar. The tribunal may determine admissibility, relevance, materiality, and weight. And we often see greater clarification or greater assistance in some of the soft law. For example, the IBA rules on the taking of evidence in international arbitration, which has been adopted in domestic arbitrations and is most known for setting out a process for the exchange of documents and for the exchange of expert reports, for example. Ultimately, evidence in arbitrations is all about fairness, and the significance of that is a fair process will avoid a set-aside of an award and the possibility of a challenge to the enforcement of an award in another jurisdiction. So although there appear to be some significant differences in the language, query whether it really makes any difference when you look at the provincial legislation in both and the model law. Another issue, and my final one, that parties often don't contemplate is the concept of limitation periods. Section 52 of the Ontario legislation says, sub 1, the law with respect to limitation periods applies to an arbitration as if the arbitration were an action and a claim made in the arbitration were a cause of action. That's pretty straightforward. If the court sets aside under sub 2, if the court sets aside an award, terminates an arbitration, or declares an arbitration to be invalid, it may order that the period from the commencement of the arbitration to the date of the order shall be excluded from the computation of the time within which an action may be brought on a cause of action that was included in the arbitration. Now, there is very little case law on this provision, and so it would be extremely risky for counsel to rely upon this provision as a saving provision in the event of the expiry of a limitation period. So best practice would be to ensure that the arbitration is brought within the time in the limitation period, and perhaps a notice of action or a statement of claim if you're uncertain about what the limitation period is. There is nothing comparable in the model law, which raises a lot of complexities and questions about what the limitation period would be in an international arbitration. And the reason it's not dealt with in the model law is probably because of the complexity. And I've sent to you, or will send to you, in the resources that are referred to in this webinar, 2 articles that are posted on Q.Arb Law, in which somebody analyzes the difficulties in determining what the appropriate limitation period might be in international arbitration. So if you're faced with that issue, it's something that's going to have to be really researched. So one option is whether limitation periods are matters of substance, for example, determined by the law of the contract, or procedural, determined by the law of the seat. And whether limitation periods are substantive or procedural is a debate that has been ongoing in a whole bunch of jurisdictions for a very long time. And so the jurisdiction, so reviewing the law of the contract and the law of the seat may well give rise to inconsistent or different results. Another approach suggested in this article is whether this limitation period issue can be determined by interpreting the arbitration agreement, the main contract itself. So it's a contract interpretation exercise. If you look then at the reasonable expectations of the parties, it's not necessarily of assistance. It's fair to assume that the parties did not think of this issue. But if they did, would they have wanted or agreed to one limitation period, none, or multiple limitation periods? And will the answer to that depend upon different legal cultures of parties across the world? Is it reasonable to assume that the parties would have considered a limitation period to be affecting substantive rights, or is it merely a procedural issue? So I've highlighted a few complexities, but this is an extremely important question, and one that I don't think is first of all, not relevant in a lot of cases, but one that I don't think is completely understood by many counsel, which is what the conclusion in the 2 articles that I'll be sending to you essentially comes to. But one final point, watch stepped arbitration clauses. Those can get counsel and parties into trouble. And stepped arbitration clauses, or multi-tier arbitration clauses, usually provide for some kind of step to be taken before the arbitration commences. And the central question is whether those first steps are preconditions to arbitration or not. Are they matters of jurisdiction or matters of admissibility? And there have been many cases which have dealt with that issue, and not always across the world in a consistent way. So if you want to have some idea about how Ontario law deals with multi-tier clauses, there's a recent decision of Maisonneuve against Clark, 2022 Ontario Court of Appeal 113. So those are my various issues that sometimes aren't readily apparent when one reads the arbitration legislation, either domestic or international. So here's my conclusion. All of these issues are actually very much tied to the importance and significance of the arbitration agreement. And so parties, counsel drafting arbitration clauses can avoid a lot of the uncertainty which arises in some of these provisions by turning their minds to them very early on and not finding them as delightful or awful surprises as the arbitration has already started. After this session, again, you'll receive my recording of today's session. You'll get a list of my Arbitration Bootcamp webinars since the beginning. And I try, as I hope you'll agree, to deal with and address practical matters as opposed to academic issues, although I will concede that the limitation period discussion was very academic, but I've wanted to try to alert you to the fact that the issue exists at all. My next Arbitration Bootcamp will not be in December. I'm sure people are already thinking towards the end of the year and all the things that need to be done before then, so I'm not going to try your patience, but my next session will be on January the 16th at the usual time. And I do have a topic for January, which I hope is intriguing. It's called Behind the Curtain, What Happens When the Tribunal Leaves the Hearing. And I've got two very well recognized and experienced special guests who will join me on January the 16th. I don't have any questions from the Q&A box, so I'll say goodbye. And I can't believe I'm saying this at the middle of November, but I hope you have a good year, and I'll see you on the other side. Have a great day.